Good afternoon, everyone. Thanks so much for coming out. This is the final installment of our three-part series on navigating challenges in technology commercialization from universities. I'm delighted to welcome you. My name is Laura Heisler, and I'm Director of Programming for the Wisconsin Alumni Research Foundation. And we are the ones that put this program together. You can look for new topics next semester, and we'll be sending you a survey tomorrow asking you how this session addressed your expectations and asking you for your suggestions on things that are important to you in this space of important topics in technology commercialization. I just want to mention a couple of practices, housekeeping notes for how this session is going to go, and then I'm going to waste no time in turning things over to our resident expert, Andrew Norman, who'll be talking about this topic that comes up every year about how to navigate the kinds of conflicts of interest that you might face as a university researcher wanting to work with the private sector. So I'm sure you're looking forward to hearing those details. We do record all of these sessions. You'll be able to find a recording on the WARF website as well as the Discovery website in about 7 days or so, 7 working days or so. Please do give us a few days to get that curated and uploaded. Because we record it, we're going to ask you to wait for the microphone when we get to the question and answer portion. So we're going to have Andrew speak to you on this subject for about 35, 40 minutes, and then we'll move to audience Q&A, and we'll have a couple of students who will run to you with the mic. So please just do wait for the mic. We appreciate that. As we always do, we're going to have an informal networking reception after the session that'll give you a chance to talk a little bit more. Please do grab a name tag for that. Andrew can't stick around for too long, so if you do have a question, don't be shy. Ask it during the Q&A if you can, and then come and have some more conversation with everyone at the reception, which will be in the atrium right behind you. So with that, I'm delighted to introduce you to Andrew Norman, if you haven't met him already. He is a senior legal counsel here on campus, and he joined the legal staff at UW-Madison in 2010. His primary areas of practice include corporate and business matters, procurement, taxation, sponsored research, and intellectual property. He's also the primary attorney for UW-Madison's Division of Intercollegiate Athletics, so that will be fun to talk about. His work at the university includes service to numerous committees and boards, including the PCI Compliance Team, the Athletic Board, and the Office of Industrial Partnership Advisory Board. Before coming to UW-Madison, he was an attorney at the law firm of Quarles & Brady, where his practice focused on business and intellectual property litigation. He's a double badger, having graduated with distinction from UW-Madison School of Business and magna cum laude from UW-Madison's Law School. And he lives locally in Madison with his wife and daughter and is sharing his afternoon with us. So thanks so much, and please join me in welcoming Andrew Norman.
Thanks. Whoa, okay. Everybody can hear me? This is really official feeling, and the microphone's making it worse. I saw the list of people that were going to be here, and it's like, wow, that was a lot of people, and then they put you in a room like this, and they have a camera, and I don't know if I was ready for all this. But anyways, let's go ahead and do it anyways. Thanks for the introduction. One of the things that I guess I wanted to add was I did start my career doing IP litigation at Quarles & Brady, so I've seen how these cases can sometimes play out. And in a twist of fate, I attended my first deposition that I've attended in probably 5 years today with a UW faculty member that had gotten involved in a startup. That startup had licensed WARF technology, and so we went through all these issues during this deposition about who was he testifying on behalf at certain points, which hat was he wearing. So it was really good, I think, preparation for today. I guess the next thing I should do is get my slide deck up. Which, do I just close this one out? Mm-hmm. There we go. All right. So anyways, that was good preparation for what we're going to be talking about today. Before we get into the specifics, I think it's important to take some time to reflect on sort of the space that university researchers are inhabiting sort of in the state and within the economy even. I think it's a fairly new concept in the grand scheme of things that the university is so responsible for innovation and is so responsible to be an economic driver of the state. That wasn't always necessarily the case. We used to have, I think, a little bit of a simpler job of finding knowledge and truth, but now it's sort of a little bit more pressure to commodify that. And to the point where I don't think it's a controversial statement to say that at this point, and at one point it certainly was. Certainly, this university has been on the forefront of commercializing the research and innovation that comes out of the university. But again, the closer ties between business and academia are seen as appropriate and desirable. Again, I think it's important to recognize that we all, especially people in my area, the UW legal office, need to realize that we need to do what we can to facilitate that and not be a barrier to it. Even as far as encouraging entrepreneurship, it's now part of our mission. And you can see that in the creation of the different programs that are available to entrepreneurs on campus to help them. So outside engagements, the good news is you can do it. Well, first of all, I meant to do this at the beginning. I know that you guys can ask me questions, but I'm going to ask you questions by show of hands. How many people here are researchers? And then how many people are administration? That is great. That's a great mix. I'm really excited to see so many researchers here. I used to do a presentation that was more focused towards outside consulting agreements for the grad school. And all the only people that would show up was administration, so I'm really happy to be talking to researchers. It's also a little terrifying to be talking to researchers because administration people tend to agree with me, but I'm not sure the researchers will. And also the fact that I have to wait until the end to hear your questions is also causing me a little bit of terror, but that's okay. Terror keeps us on its toes. Let's go. The good news is you're allowed to do outside activities. Okay, no applause, that's okay. Maybe next time. Maybe we'll get in each other's flow a little better next time. So long as the outside activity does not conflict with the employee's responsibilities to the university, so long as the relationship does not conflict with UW system or state of Wisconsin policies and rules, so long as potential conflicts of interest are managed, so long as the terms of relationship do not improperly encumber the intellectual property of the university. As long as those 4 things are there, I think you're good to go. So that's my talk. Any questions? Just kidding. But these are the 4 areas that we're going to discuss throughout the remainder of the presentation. First, conflict with university work. This is sort of the easy common sense one, but we'll get it out of the way first. Obviously, you can't let your entrepreneurial outside activities take the place of your daily job. You have to keep on doing that. Keep on researching, keep on doing all that kind of stuff for us. As long as you're continuing to perform the things we're paying you to do, no problem there. The other half of this is make sure you're not improperly using university resources. This is a problem because it's obviously improper to use university resources for your own personal gain, but it's also just a really good idea, right? So don't use other university employees. If you've got a deal with an outside company and you want to bring somebody else in, have them also have a deal with the outside company, right? This is especially difficult if they're a subordinate of yours. Make sure that we're not utilizing those type of people for your outside work. Obviously, students, it's a tough situation to put a student in. We'll talk a little bit more about that later. Facilities, if you need to use university facilities, contact somebody in the dean's office. We can maybe work something out where you can use them as an outside user, but make sure you're not just using your university facilities to do your outside work. Same with lab supplies. I think probably the most important one from a day-to-day basis is IT resources, and I think there's 2 fairly important reasons for this. The first is if you're using your UW email, your UW computer to do your outside work, it's going to cause confusion as to who you're representing when you're doing that work. So it's important to be very clear. If you have your own company, make sure your emails come from that company when you're doing company work. If you're sending emails and things as a consultant, I think your own personal email would be a good idea, just to be very clear on who you're working for at the time you're working. The second reason why I would do it is Wisconsin Public Records Law. Now, your consulting related or other business startup related emails don't become public records necessarily that are going to be produced simply because you put them on your university computer or because you use university email. But they may need to be searched, right? And we may need to make that determination. So if you don't want that commingling to maybe come across my desk sometime, it's important to use a different email address and a different computer. And that's also really good advice for personal emails too. I mean, I know that we've had situations where unfortunately we've had to search emails and some of the personal stuff comes through. It doesn't get produced under the law, but that doesn't mean people that you might know would maybe not see it. So something to keep in mind. The second one is probably the second easiest, so we'll take care of it now. There are some state and system rules that would be related to your work outside the university, either in a startup or in a consulting mode. The first thing we should look at is UW-S8. And it's a very long statute that says the same thing 3 or 4 different times. But essentially, the takeaway is that you shouldn't use your public position for personal gain, so that could be money or other things, in a manner contrary to the interests of the UW system. So that's what, saves most of these situations is, the fact that you're a consultant, you can have the fact that you work for the university and have the experience you gained here can make you valuable to somebody else, and you can profit off of that, but it's not in a manner contrary to the interests of the system. So, the way that we manage this mainly is through the reports that everybody has to file every year. I don't even know who receives those, but our outside activity reports, you get a reminder every year and you file them, and then I think Dean's office takes a look at them. And those will need to be disclosed in that report every year. We'll talk a little bit more about that later. A very specific rule is that there cannot be a contract or lease between staff and the UW involving more than $3,000 over 12 months if the staff member is in a position to approve or influence the decision to enter into the contract. This doesn't come up too much, but it can. So if you are in that kind of contract with the university, again, it's always good to disclose to your dean's office so we can work through these kind of things. The other things that the ethics rules require are when staff are supervising students in research projects, they should disclose any financial interest to the students. So if you've got somebody that's working on your science, and maybe there's an outside company that you're a part of that's funding that science, the student should know that. It requires the university to establish an institutional ethics committee. Requires staff to notify deans or directors of potential conflict, which is managed at the dean or director level. So we'll talk more about conflict of interest in a bit. And I don't, I think I'm going to stop putting this slide up there. I don't know of anybody who's gone to jail for this. I don't know if anybody's been fined for it. I guess it's just to let you know that we're really serious about it. But here you are at 4 o'clock on an afternoon coming to learn about this stuff. I know you guys are serious about that. So nobody's going to jail. But it's good to know that at least theoretically it's there. We have one more scary rule that even has more jail time. But I wouldn't necessarily worry about that at this point. And that's this one. That's called the Felony Self-Dealing Statute, 946.13. This one's even more confusing. I would not invite you to pull up either of these statutes to try to understand them. Rather, I would invite you to call our office if you've got a concern about either of these statutes. This one is very, very confusing. It's essentially, the key language in this one is somebody in their public capacity participating in the contract process or having the ability to exercise discretion with respect to a contract in which they have a personal financial interest. That's a lot of words. Where this comes into play, as far as you guys are probably concerned, is if you have an outside startup and and that startup, wants to fund research within your own lab. Okay, that's a contract then that if it's in your own lab, you're going to have discretion with respect to how that contract is played out. Okay, and it's not that you can't do that. It just has to go through the institution's conflict of interest process to be able to do that. With the caveat that if this is a big funded research, if it's more than $250,000 over any 2-year period, it's actually going to have to go to the Board of Regents for approval. So Bridget Daly in our office takes these pretty much to every Board of Regent meeting. There's one every once in a while. Certainly, 5 or 6 a year to get their approval. We've been working very, very hard to get rid of this requirement. We think that this is simply a waste of time. Do we have any regents in the audience? Anybody who's like regent adjacent? Okay. We don't think they add a lot of value to this process. Usually they just sort of wait the time period that they need to approve it and it's deemed to be approved. In the meantime, work can't get started, right? And the reason work really can't get started is because this one is serious, right? Punishable by a fine of up to $10,000 and imprisonment not to exceed 3.5 years, right? So that's going to set your research back. And you can tell that this statute was not drafted with this kind of thing in mind. It wasn't meant to put people in jail who fund research within their lab with their outside company, but here we are. So those are the state and system rules. The third thing that we were gonna talk about is conflict of interest management. And I don't want to get too much into the specifics of conflict of interest management and how that works necessarily, but I wanted to spend this time to give some thoughts on sort of theoretically conflict of interest and I hope it can be thought about on campus. And sometimes I think it's thought about a little differently. The most important thing in my mind is to understand that, at least from the university's perspective, conflict of interest is not necessarily a judgment on your actual motivations, right? I think some people hear, you have a conflict of interest, and maybe the reaction is, well, no, I don't. I mean, I have very clear ideas here. I'm not trying to do anything that's conflicted. It's really perception of a potential for conflict, right? It's not actual motivations. So it's a situation where somebody from the outside could look in and say, would that change behavior? Is it possible that that's going to change behavior? And if that situation exists, it doesn't become a question about actual motivations or actual behavior changing, but rather, what do we need to do to make sure that this perception can be corrected? And I think that this was really interesting. I found this when I was working on this slide deck from the Office of the Vice Chancellor for Research and Graduate Education. Very explicitly saying that conflict of interest is part of the Wisconsin idea. It's part of what we're doing here. It's inherent in the Wisconsin idea. Taking things from the university and going out and sharing them and commercializing them is what we do, right? Where knowledge gained from academic enterprise is shared to benefit society, right? Faculty and staff are encouraged to participate in outside activities, share expertise, and transfer intellectual property to the private sector. Your participation in outside activities may generate conflicts between the needs of the institution and the outside entity. UW-Madison understands that these conflicts are common, frequently unavoidable, and can often be appropriately managed. So that's a lot of words to say, don't be afraid of disclosing the conflict of interest. We understand it's something that happens. It's not something that we are going to try to find a way to get rid of, right? We're going to try to manage it. That being said, we do have to, if possible, manage them, right? Mainly because the certain outside consulting activities and other sort of startup situations could have the perceived potential to influence the outcome of university research, right? Or the health of human subjects. This is why people do research at universities, right? If you want an unbiased answer, you come to a university because they know we're going to publish it if it's good or bad. If we're looking at a drug, we find that the drug is toxic, we're going to publish that. If the company who owns the drug does a study and finds out the drug is toxic, we don't know what they're going to do, right? So this is one of the most important things a university can have is this concept of unbiased research. And in order to maintain that, we have to keep management of conflict of interest so people can continue to see us that way. Second bullet point, it promotes this unbiased research and ensures the safety of research participants. I think going through the conflict of interest process also protects researchers, right? Something comes up, your results are questioned, and then we find out about this pre-existing relationship. You're going to want to be able to say, I disclosed this, right? I disclosed it on my yearly conflict of interest form, my outside activity report. If there was a change in my holdings or my involvement with a company, I told the university that within that year. And then every year I filed this new report to tell them so that it could be appropriately managed. So this is not something that I need to worry about now going forward. Because the university has both legal and ethical responsibilities to manage conflicts of interest related to university research. So the outside activity reports are the primary way we do that. They're reviewed and managed by the UW-Madison Conflict of Interest Committee. Researchers participating in consulting activity must be aware of their obligation to file a yearly outside report, again, and to update the report if their consulting arrangement changes. I think that's probably the one area where I guess I'm a little nervous we're not capturing everything. I mean, we know when everybody files their yearly report, you all get the email. If you don't file the report, you all get another email, and then we can keep track of everybody who's done that. Where this gets a little bit, where you could get into trouble is if something changes materially during the year and you don't update your report. That would not be in line with our policy. Here's a good website. Put that on there for your outside activity reports. We don't need to get too much into the specifics here, unless if somebody has a specific question, maybe we'll save that for the end. Okay, so that's the first three prongs of this. And so with so many things that involve startups and the university and consulting, I think most of the rest of the time, I think we're going to talk about intellectual property. I hope that's okay. I think it's the most complicated aspect of working with somebody else outside the university. I think it's the most complicated aspect of having a startup. So we're going to talk about some strategies in your agreements with third parties, whether they be consulting agreements or the foundational documents that start a company, how you can make those play nice with your obligations to the university. And frankly, how we can help prevent researchers from giving away more than they want in a consulting relationship. I mean, just at the outset, I've reviewed enough of these to understand that the $50,000 to $100,000 consulting arrangement terms are not necessarily more onerous than the $600 speaker's fee terms, right? It's just, you have to look at them and decide whether it's what you want to do and whether it's worth it. So the first caveat I think I have to give is that I represent the University of Wisconsin, right? So I cannot give legal advice to any UW researcher to the extent that they are doing something outside of their work for the university. So if you're doing a consulting arrangement, you're keeping the money, obviously, which is good and you should. I can't act as your attorney, and you probably wouldn't want me to. You could find more qualified people out in the city to tell you about your contract than me. That being said, we do get a lot of calls where people send their consulting agreements and things to us, and they say, can I sign this? The answer is yes, you can, but I'm not telling you that as an attorney. I'm telling you that as somebody you can literally pick up a pen and sign this if you want. That being said, we can give you our thoughts and feelings as to, if this was me, I probably wouldn't do that. But again, we have to be very careful to not purport to act as your attorney in a situation. That would be a conflict of interest on our part, and it's all come full circle. So I think if it's a big deal, or if you have, a lot of potentially very valuable IP, I think it would be a good idea to consult with your own attorney and to have that person understand your situation and weigh in on an agreement. I've dealt with researchers who are so accustomed to this kind of arrangement, they would do a better job negotiating the contract than I would, quite frankly. One of the nice things that we are able to offer is the Wisconsin Law School's Law and Entrepreneurship Clinic. That's been an incredible help to at least have a place to send somebody, especially maybe a newer entrepreneur type or a newer researcher that maybe doesn't have the willingness or the funds to go get their own counsel. We've provided them some training. It's been a little while now that I think about it. We should probably do that again. But to help maybe newer people work through these concepts. Again, if this is like a multi-million-dollar sort of deal, though, I think you'd probably go get an attorney. Some things to keep in mind. When you're dealing with a company, they are generally concerned with protecting their own intellectual property, and often they are trying to get your intellectual property. That's just a true statement. Something to keep in mind. These goals are often in conflict with your obligations to the university, and even to maybe what's best for you going forward, right? Just because it's something you can do in your university appointment doesn't mean it's a good idea for you to do for your science, and we'll talk about that a little bit later. Where this gets really concerning from the university's perspective is when these goals conflict with the obligations the university has to the federal government or to research sponsors. Some ideas. These are the most important parts if you're entering into agreement with an outside company. Avoid granting rights to intellectual property that is already encumbered or is the property of another, and we'll talk about some ways that can happen. Avoid agreeing to limitations on future funding from other sources, which comes in a surprising amount. Avoid agreeing to refrain from research on certain related topics of increase. Sometimes this can happen in sneaky ways as well. If you agree to certain confidentiality provisions, all of a sudden you've agreed not to disclose something that maybe you already knew in a paper or in a publication or in a grant application, and that can be a problem. And then just some common sense stuff. Avoid giving warranties regarding any deliverables, because that's really tough to promise as a consultant. The most important, most concerning aspect, as I mentioned, from the university's perspective is probably that the fear that one of our researchers will, in their private dealings, give away university or other IP. This is especially a problem when the work is federally funded. big time consequences. You know, I don't think we want to be in a situation where we're somehow suing the company that you've either started, or the company that you've started is suing us, or we're trying to invalidate their patent, or they're trying to invalidate our patent because of an agreement you had with them, right? That's not a comfortable position for anybody. So we'll do what we can to avoid that. I think we do need to take a step back and talk about how this conceptually, I think, is a little bit more important for UW researchers maybe than your peers. We are somewhat unique because of our policy. And that's actually a different policy number now. Anyways, they changed that. We don't automatically take all your intellectual property when you show up, right? So if you show up at most universities, especially I'm not going to say all, but top tier research universities, when you show up, you sign something that says, I'm assigning you the intellectual property I come up with when I'm working here. And that's a very simple conversation, and that's what you have to do to work there. Per our long-standing policy, we don't do that. And it's true whether you're working outside the university or working for the university. Of course, as you may know, this is subject to two fairly large caveats. The first is federally funded work. As part of accepting the federal funding, the university has the right to take title to any invention that you create under that federal funding. So as part of that scheme, that word has a negative connotation, I don't mean, as part of that process, we do have you assign any little intellectual property that's created under federal funding to us. The other part where this comes in is usually when an industry is sponsoring research, they put it in the contract too that they want the university to obtain and assign to the industry sponsor, either through WARF, usually through WARF, any intellectual property. So it comes to the question of what's left if we're talking about not federally funded, not industry funded. I understand that that's not a huge world of funding around here, but it does exist. And we'll talk a little bit about the federally funded side of this as well. But it's good to keep that in mind, that technically, with the base point here is that you own your IP. Some recent legal, this says recent, this slides are getting a little old because these aren't that recent anymore. But these two things sort of came out around the same time. The first is the American Invents Act. Everybody familiar with that? Show of hands, who's familiar with the American Invents Act? And who's familiar with what it did? That's pretty good. So we used to be a first to invent country, sort of out of line with the rest of the world, as I understand it. And the American Invents Act turned into a first to file sort of patent system. So if two people, without stealing each other's ideas, both came up with the same invention at around the same time, the person who gets the patent is the person who files it first. That's a very simplified way of saying it, but I'm afraid to say anything more with Stephanie here because I know she knows it a lot better than I do. But what this means is it's generally thought, and I don't know if this is borne out in practice, that companies with a whole host of lawyers are maybe more able to file those patents and flood the patents out there and get priority, maybe more than a university. Now, we have a very prolific patenting university, so this isn't that much of a concern to me, but it's something to keep in mind. The second thing that, it's possible that I'm the only one that still cares about this, because I've talked about Stanford v. Roche for, I don't know, when did that come out? 6 years ago? 5 years ago? I've talked about it in many, many presentations. I like to talk about the case because I think it's a really good example of how these things can go wrong. And I also like to talk about the case because I think it's still a problem for the University of Wisconsin, and I want everybody to understand it. So bear with me. All right. Who's heard of this case, Stanford v. Roche? Okay. I'm going to give the basic facts. I think I have most of this right. I've said it enough times that maybe I've started to make some of this stuff up, but I think it's true. Okay. There was a faculty member who had just started working for Stanford. He shows up on the first day. They have him sign a letter saying, welcome to Stanford. Please agree to assign us any intellectual property that you come up with. He signs it. Great. Working at Stanford for a little while, they think it's a good idea for him to go learn a process at a nearby company called Cetus. So he goes to Cetus. Before they let him in the door, he has to sign another agreement. This is outside activity at Cetus. It says, I hereby assign you any intellectual property that I create based on access to what you're about to show me. Signs that, they both put it in the file. Works at CETUS, learns this process. I think it's related to HIV detection technology. I think. Learns this process, kind of comes up with an idea, goes back to Stanford, goes back to his lab, obtains some federal funding, uses that federal funding to finish the idea, reduce the invention to practice. So now he's got this invention. Files it, discloses it to Stanford. Stanford files a patent, obtains a patent, looks around in the market, says, you know what, I think Roche maybe using this patent, or maybe about to, or maybe already infringing it. Let's go contact them, and we'll get them a license, we'll get some money back, this will be great. They contact Roche, they negotiate, I think, for a while, can't agree to terms. Stanford says, you know what, this is the last chance, take a license. Roche is like, no. Stanford goes, fine, we sue you. Roche says, funny story, we bought CETUS. And we've got this assignment from Dr. Halidny, the faculty member. This is ours, okay? So we can see lots of problems with this, right? This is the kind of situation you want to avoid, where your university is fighting with the company that you're either started or consulting for, and you're in the middle going, I don't know what to do. Anyways, so they fought and fought and fought, eventually went up to the Supreme Court. A whole bunch of issues related to these competing assignments. But the question that went up to the Supreme Court was, does the Bayh-Dole Act, which I'm assuming most of us are familiar with, the act that allows the university to take title to inventions that are funded with federal funds, does the Bayh-Dole Act in and of itself give this to Stanford? This was reduced to practice with federal funds. I don't care what these employment letters said. This is Stanford's. That was the claim. The Supreme Court said no. No, this is all still very dependent on Stanford having achieved the right assignment, right? Okay, so they lost a patent, essentially. They didn't have the ability to sue Roche for this because Roche had ownership. Stanford went back and said, boy, we should probably change all of our employment letters. Well, I should take a step back. So then the court based it on these two letters, right? So Dr. Halidny had told Stanford, I will assign you the IP I create. He had told CETUS, I hereby assign you the IP I create. Even though the CETUS one was second, that one word basically made that have priority, and Stanford lost out on it. So Stanford said, well, that's not great, but let's just change our appointment letters and we will do hereby assign in the appointment letters and we'll just fix this. And every other university in the country probably said, you know what, we should look at our employment letters and we'll fix this and we'll put hereby assign. University of Wisconsin doesn't have that letter, right? So we're in a situation where we need to get these valid assignments from all of our research on campus, especially ones doing federal work. We don't have this sort of entry claim of IP. And the reason why I'm bringing this all up is because I think this puts a little extra pressure on our researchers to avoid situations like this. Well, it puts extra pressure on the university, really, but on the researchers to clearly define who owns what when they enter into their consulting agreements, right? And just as by way of background, I've been trying to make it so that maybe this is where I'm to administration, and I shouldn't be saying that this is a virtuous thing, but I've been trying to get it where people can't get paid on a federal grant unless we have this assignment documentation in place, and I was told, no, we can't do that. And then I was trying to add it into our employment letters, and I was told we can't do that. So you'll hear about this. We'll lose a patent someday. Just remember this. Remember me. Remember, and I will be sad for the university, but I will feel vindicated. Anyways, so that's why this is important. Copyright gets a little tricky. This is my least favorite policy. Copyright ownership doesn't require that kind of assignment as that patent does, right? So the general rule is that when you create something that's copyright protected for your employer, that your employer owns it. We've taken the step we've taken a step back from that. The university does not essentially try to claim ownership of all copyright. We only try to claim ownership when substantial institution resources are provided to support the development of the copyright protected work. This is a really odd concept. I want to give an example. So, I don't even know how many years ago this was. 5 or 6 years ago, the big thing was the massive online open courses. Do you remember, who remembers MOOCs? Anybody remember? Anybody still working with MOOCs? Okay, right, I haven't given up either. All right, so we had this big deal with Coursera, right? And it was a really interesting discussion about copyright. Who's gonna own the course that's on Coursera, right? And how we applied this rule, I think, is a good example. So the faculty is going to own their ideas, they're going to own their syllabus, they're going to own the way they arrange their course, all that kind of stuff. But in order to get this class on Coursera, we had to get a videographer. We had to do some video editing. We had to do some coding to make it work on the Coursera platform so that it could be, put out to hundreds of millions of people for free across the world, right? So when we talk about copyright ownership, that was an interesting copyright case in that the university took the position that it actually owned the thing that got uploaded to Coursera, with that it took all those university resources, the filming and the coding and all that kind of stuff. But that didn't mean that the faculty lost ownership of the underlying class. I hope that makes some sense. That's as good as I got. It's not a clear policy. We've been trying to rewrite it for years, and hopefully we will actually do it one of these years. The thing with copyright, especially if there's multiple authors, the advice there is basically, if you think something's going to come out that you can maybe make use of commercially, figure out who's going to own it going in amongst yourselves. That's the most important thing we can do, is have agreement going in before something's created. This gets difficult when you start doing multi-year open source software programs and things like that. And also, I don't have answers, so that's So one of the things that sort of comes out, I think, of the Stanford v. Roche case is there's this idea of commingling. It's probably not a great idea to take an idea that you came up with at an outside company and then go ahead and use federal funding to reduce it to practice. That's sort of like worst case scenario as far as commingling. But from a basic, you should be able to say, this is this work within my lab at the university, this is this work that I'm doing outside. I can tell you what funds are going to which, I can tell you what scope is going to which. And if there's confusion there, it's at least has the possibility of an issue, especially if there's federal funding involved. And then the terms of the consulting agreement, even if you keep all your work completely separate, right, where you can draw this clear line between work you're doing for the university and work you're doing outside the university, terms in the consulting agreement can bite you. And we'll talk about that a little bit. The university in and of itself won't grant rights to background intellectual property. We would suggest that if you're dealing with another company, you don't either. Mainly because I don't think at the time of contracting you have any idea what the background intellectual property might be to what you eventually create for the outside company or for your own startup, much less who owns it, right? The background intellectual property for the thing you come up with might be somebody else's, might already be licensed to somebody else. Or maybe you just don't want to give them everything you've ever created, right? Maybe your life's work isn't worth this consulting relationship, if that's the language that they're insisting upon. This one's sneaky too, right? Let's say you're going to enter into a consulting agreement and it says that the company gets all intellectual property created during the term of the consulting relationship. I mean, that makes sense. That sounds okay, but not if you're also working at the university during the term of the consulting relationship, right? If it's just a time frame, that anything you came up with that time frame is the company's, that's a bad idea. Such language should be revised to include only intellectual property created in the scope of the work for the outside entity, not during the time frame. That's a lot of language that you could definitely try to get inserted in your consulting arrangements or other arrangements with industry. I've had less than 100% success getting this many words into consulting agreements for other people. But basically, here's what we would suggest. From the university's perspective, to protect the university's assets, I don't think you could run into a problem with the university if this was in your consulting agreements. That doesn't mean it solves all problems, right? I think it still would be possible to give away too much of your own personal intellectual property, but this is what we would like to see, something like that. I've come up with a shorter version, still a fair number of words. Are these slides going to be somewhat available? Because, well, actually, there's a website too. We put out a consulting website that contains all this language, and maybe I'll drop a link to that somewhere. In some ways, this is as important. They don't, again, I don't want to paint too negative a picture of companies trying to do business with you. I'm sure you have good relationships with very good companies that would never take advantage of you, and I don't want to paint with such a broad brush. But it's not always the case, right? And sometimes they don't necessarily just want your IP, but they do want you to not help their competitors, right? So sometimes these agreements will talk about you not competing or working for companies that compete with them. And are you willing to not accept sponsored research in your university lab because of this consulting arrangement? That's a decision you'd have to make. Restrictions on application for acceptance of future funding, restrictions on publication on certain topics. That's a hard one, especially if it's really related to the work you're doing here. You all know you have to publish. It would be a shame if you got sued for publishing because you entered into a consulting agreement where they said you couldn't do it. Obviously, restrictions on continued research in a certain field or accepting engagements for other entities. This was kind of amazing today. So I told you about that deposition I was at today. I won't obviously give details, but the researcher here was actually acting as an expert witness for one of the companies and evaluating trade secrets of another company. And in order to get access to what those trade secrets are so that he could evaluate them, he was asked to sign the court's protective order. So this is the protective order that the court had said, we're going to put this in place. If anybody wants to give confidential information or file it, they'll just mark it confidential under the protective order and only these people can see it. So this was a court-authorized document that was drafted by the parties. One of the stipulations in this document was that if you get access to this information, you are prohibited from filing a patent application in the area for 2 years. Now, I think the intention was to prevent counsel, maybe, from modifying patent applications, but our employee, researcher, witness read this and said, well, no, I'm not going to do that. And it was really a great decision on his part. I mean, that would be quite a limitation just for access to some for a expert witness fee. That's giving up an awful lot, 2 years of not patenting in your field. And I guess I bring that up just to say that no matter how sort of standard the documents look that you're entering into, there can be some scary stuff in there. And it really is important, especially in this area, to read it and to think about what that might mean for you. Another area where this can sneak in is confidential information clause, right? It's not necessarily an IP clause. It's not saying you won't compete. But if you've agreed that you won't use the information that you've had access to at the company, and they give you access to a whole bunch of things you already knew, or access to things that maybe were sort of publicly available, now all of a sudden you have a question of whether you can use this information you didn't need them for anyways. So here's some suggested language to carve out confidential information. What you're trying to avoid is the idea that everything they give you is confidential and that you're prohibited from using everything they give you. Again, what if they give you things, presumably you know more about what they're looking into than they do, right? And that's, oh goodness. 5 minutes before questions. Excellent, okay. So keep that in mind, right? That everything they give you probably isn't going to be a surprise to you when you go to a company, right? So make sure you carve out things that you could otherwise get or things you already knew. This is just a good idea to protect yourselves. This doesn't really concern the university, but if I was going to work for somebody and provide data to them or work to them or deliverables to them, I would not warrant that what I'm providing them doesn't infringe somebody else's patent, because I have no idea, right? I'm not a patent attorney. I don't know what's out there. I'm going to do the work, and I'm going to give it to them, and then they can have their presumably, team of lawyers look into whether they can seek patent protection on it or whether they can practice what you've given them without infringing somebody else's patent. But I'm not going to promise that it doesn't infringe somebody else's patent because I don't have the ability to determine that. And I don't think that's some situation you want to put yourselves in either. So we suggest trying to remove that. The bottom line, at least get it changed so that you agree that you won't knowingly provide somebody else's intellectual property to them, but don't warrant that it's not. Here are some other issues that can come up in these agreements that we think are a bad idea. I mean, I don't think you should be agreeing to indemnify a company if something goes wrong. They tend to have more money than you do. Let them work it through their process, especially if you're not insured or if you haven't set up an LLC or something to protect yourself. I wouldn't indemnify a company. Sometimes you have to go and if there's a dispute, you probably don't want to end up in California litigating the thing. It sounds like a small deal, but it is until it isn't, right? And then long restrictions on confidentiality. We talked about confidentiality a little bit before. I sort of said this at the beginning too, but I want to highlight it a little bit. And I don't want to be overly paternalistic, but I really would think long and hard before signing a lengthy agreement related to especially a small dollar situation, a speaker's fee or a one-day presentation or a symposium or something, or a very small consulting arrangement. You can get into the IP terms and parse, this is mine, this is going to end up going to the university, this is going to go to the company. It can all make sense. But there is always the possibility that even the existence of that arrangement is going to cloud your future intellectual property, right? So when you submit it to WARF here, and they're going to look and they say, well, there's this consulting agreement out here. It's not clear that this is, it looks like this isn't under that, but there's that extra level of hesitancy there. There's that extra concern. If you're starting a startup and you're trying to get funding, right? The last thing you want is this little thing floating out here that might have investors wondering whether somebody's going to come and challenge your patent or try to claim ownership of what you're trying to build your company on, right, in 2 years because of this agreement that's out there. It's not to be overly I don't want to scare anybody, but it is something to think about, whether even if you have all the right terms in there, it's worth clouding your intellectual property in any way going forward to do this kind of thing. And it's always, if it's not, it's always worth the attempt just to say, you know what, we're going to cut out this IP section, and I'm going to own everything that I tell you about, or that I do. And if you want my help, you can either take it or leave it. Just a thought. What a cheery last slide. Okay. Oh, it was too. It was the last slide. So I think we have that timed up pretty well. All right. Any questions? Yes. We're going to wait for the microphone. I refuse to hear any question without the microphone.
Have you encountered situations where the terms might include a requirement that disputes must go to arbitration rather than to a court? And what is your advice if you encounter that type of requisite?
Good question. Yes. Arbitration is court. I mean, and I know that's not what people think. When arbitration first came out as an idea, it was thought, well, we'll streamline this and we'll make it cheaper and we'll all just go to a conference room and it'll get settled, okay? The arbitrations that I've been a part of are they're just different venued court cases. You still have all the discovery, you still have all the attorneys, you adopt similar rules. I've been involved in arbitrations that were worse than local court cases as far as complexity and time. As a consultant, or as somebody who's entering into a contract with startups, things like that, certainly you can agree to arbitration, spell out how it's going to work. The university is prohibited from entering into those types of agreements. Arbitration awards are not enforceable against universities, so we tend to say no to arbitration. But we don't say no to arbitration because we think it's any sort of disadvantage or anything. It's just not something we can do. So I think arbitration is fine, but just understand that if you were fighting with somebody over a serious issue, a serious intellectual property claim, it's going to be essentially the same cost as court, really, in the same time, I think, in a lot of different ways. I mean, you can get stuck in some courts where it's years, so I guess I see it in that way. Pay attention to where it's venued. Again, where do you want to have the arbitration? Do you want to be traveling to California every time to do your case? I don't know. The other problem is if you get a really bad result in arbitration, you can't appeal it. That could be a benefit. That does streamline the process a little bit. I shouldn't say you can't appeal it. You can appeal it, but the standard is if they've done something crazy, not as if the upper court disagrees with the arbitration award. You guys decide who gets to ask the next question.
So you spent some time talking about the conflict of obligation, but as somebody that's quite green, I guess I came to try and figure out if there's a way to acknowledge perception. So, you get so excited that you're about to engage on this new venture, and then the language trips you up. So, you can say you're welcome to leave or get out. They're the same thing, but one's a positive way of saying it, one's a negative way of saying it. And so sometimes when you read you're welcome to leave, you're like, oh, well, I'm going to choose to go, not realizing that someone's just insulted you. So you did mention there was a clinic, but is there some language use in that would predispose a conflict?
I'm not sure I understood that question. You're talking about language in what?
in trying to come to an agreement where you're sharing your potential while you're also being in compliance with your employer or your university obligation.
So you're talking about a conversation with somebody outside the university.
I guess. So I'm green, so it's hard to be succinct, and I do apologize for that.
But that's okay. I just think you're asking a deeper question maybe than I'm ready for.
Well, all right, maybe that's possible.
Okay.
Or it's beyond the scope of the presentation, maybe too. But what I was hoping to ascertain was just a way to maybe have more clarity, more understanding of when you're going into an agreement about sharing your knowledge and your expertise, that you don't give away more for lack of understanding because of the word choice in what you've signed away.
So, in a situation where you're really excited to work with somebody, positively setting boundaries as far as your intellectual property, without sounding negative, I think that's a good idea. It's hard to think of, the type of intellectual property term that might come up. Again, I think it's okay with the caveated language or something like that, just to recognize that your employment, your primary employment is with the University of Wisconsin. You can agree that you will, give them rights to any intellectual property you create within the scope of your consultancy relationship with them. And if they want more than that, I think that the response, at least from the university's perspective, should be, I don't want to promise you more than I can legally give you. And I don't want to promise you something that is going to cause me to cause the university to violate its obligations to the federal government and to other sponsors. So I can agree that, respecting those university commitments, I'll come work for you and we'll agree on the scope of work that I'll do for you, and you can have rights to what I do for you. But, I just want to make sure that I'm not over-promising what you're going to have rights to, right? And that works out for everybody.
Thank you for the talk. I have a question in regards to IP ownership assignment. And I'm going back to your slide when you said there might be a limitation using university resources. And your example about the trademark case made complete sense when university resources were used. What are your thoughts on if you pay for university resources, such as rental fees, for equipment and locations? How does that limit or does that not apply?
I think that's good. I think that takes away a claim that somehow you're taking university resources for your own personal gain, right? I think that there are times when universities have taken the position that if you do this in our facilities, we own it under our policies or under the law. I don't know that if we're relying on buy-dole kind of concepts that actually works, so I'm not going to say that the university owns everything you necessarily do in our facilities. But if you do something in our facilities and you enrich yourself, that's its own problem, right? That's misuse of university resources. And if I were going to start a company based on technology that I developed, I would want to be able to point to where I paid market value to the university for what they've contributed, so that's taken care of, right? That quiets that concern over here. So I think there's value if you feel the need to use university resources, but it's not within your university work, it's with your outside work, to just quiet any noise that could come from something like that.
I actually refer, as a researcher, I use equipment that is provided by the university, and you rent the equipment.
Okay, from a center?
Or it's at the Wimmer.
Okay.
And you rent ultrasound machines because that's owned by a certain department.
Yep.
So you pay for that service. Mm-hmm. So does that technically fall under that limitation?
Are you still doing university research? It's just coming out of your budget?
Yes.
Yeah, then it depends on the funding, right? So if that's federally funded and you've taken a portion of that, and it's just if it was federally funded, the university would still have rights under by dole.
And that piggybacks on what if it's funded through an accelerator program here that is not considered federal funding? Does that fall under the same limitations?
I don't believe it does. I'm not familiar with the terms of the accelerator funding, but I don't know that is there a Stephanie?
I believe the terms of the accelerator program do require assignment, so if you're using that research. I believe the terms of the accelerator agreement do require assignment, and often there's underlying intellectual property that is the purpose of the funding to accelerate. So what you're often looking at are improvements to the underlying intellectual property, and it is generally committed as far as my understanding goes.
And then we'll have one more question after this one, if that works for everybody. So think of a good last one.
Thank you for your presentation. Would you recommend us to form a company before we do consultancy with all the personal liability?
I think that's a good idea. Yeah, and I can't advise you as we've discussed, but I see advantages, especially if it's a situation where you're going to agree to terms like that. Yeah, it would be to protect your own personal assets. If it's something you're going to be doing a lot of, and we're able to keep up with the filing requirements, and it was worth putting in the money up front to establish it, yes. For like a one-off deal, that seems like it'd probably be more hassle than it's worth. And I don't know how it would affect your personal taxes. But yeah, if it was something that you thought you were going to engage in for a fair amount of time, protecting your own personal assets and having there be assets in the LLC could have some advantages.
Thank you.
I'm also okay just getting, okay, one more question, last one.
Do I need a
Thanks. Yeah, could you give a brief discussion of the differences between the statutes and the administrative regulations, particularly with regard to questions like enforcement and penalties of violations of those?
Man, I knew the last question was going to be like a hard one, like a long, hard one. I would just go back to the slides, and I don't want people to leave here trying to parse between sort of the administrative code and the felony self-dealing and anything. I mean, I think from your perspective, I don't think you need to really understand the difference. Just that I think you need to understand your obligations to disclose any interests or potential conflicts that you have. Once it gets to that place, once you've disclosed that, you're personally out of the woods. In these situations. So what we're trying to get to is the point where people are disclosing any concerns they have. And don't ever be afraid to disclose something, at least from our perspective, that didn't need to be disclosed, because it'll be disregarded then, right? There's no real danger in that. So as long as you're disclosing through your outside activity reports and updating them and bringing any questions to your dean's office to get filtered to the right thing, I'm really hesitant to have anybody sort of parse these things. If you have any concerns, we can help you resolve them. And again, we are interested in managing these kind of things. We're not interested in getting rid of them, right? That's something you don't see in these slides, is we're not trying to take out all conflicts of interest, because we understand that that's not possible.
So with that, I want to remind everyone we're going to have a reception, and we will be putting these materials along with the recording on the WARF website and the Discovery website in several days, so you can find all of that there. And please join me in thanking Andrew for a very informative presentation.